If your company paid tariffs to U.S. Customs and Border Protection in 2025 or early 2026, what I'm about to tell you could be the most important news your business has received all year. The United States Supreme Court has ruled 6-3 that the emergency tariffs imposed under the International Emergency Economic Powers Act were unlawful. That means the federal government collected money it was not legally entitled to collect. And the government may owe your company every dollar back, plus interest. I'm Dr. Wendy Walsh, and joining me today is Michael Stanley, managing attorney and founder of Stanley Law, a Houston-based litigation firm with more than 30 years of experience going up against really powerful corporations and institutions on behalf of people and businesses who deserve justice. Now, Michael started Stanley Law with a very simple belief that no corporation, no institution, and no government agency is too powerful to be held accountable. Over his career, he's represented hundreds of investors who were defrauded by an $8 billion international Ponzi scheme, families injured by dangerous products and chemicals, and clients in complex, high-stakes litigation across the country. Stanley Law works on a contingency basis. Now, that means that you pay absolutely nothing unless they recover for you. The firm is now actively representing businesses in the IEEPA tariff refund litigation. Michael, thanks so much for being here.
Thank you, Wendy. I'm glad to be here. At Stanley Law, our lawyers have spent more than 30 years fighting for people and businesses that are up against opponents with more money and more power. The federal government has collected over $166 billion from American businesses under tariffs the Supreme Court has ruled were illegal. Our job is to make sure those businesses get their money back.
And good work that you're doing, Michael. Now, for viewers who might not have been following this as closely as we have, take us back to the beginning. What happened and how did we get here in the first place?
It starts in early 2025. The president signed executive orders imposing tariffs using a law called the International Emergency Economic Powers Act, IEEPA. Now, IEEPA has never been used this way before. It is an emergency powers law. Presidents have used it to freeze assets and impose sanctions on foreign actors, but using it to impose sweeping tariffs on imported goods from essentially every country in the world, that was a first, and it was immediately controversial. American businesses, importers of record, started paying enormous tariff bills to U.S. Customs and Border Protection. Some paid hundreds of thousands of dollars, others paid millions. And almost immediately, trade attorneys and legal scholars started asking the same fundamental question. Does the president actually have the legal authority to do this?
And the courts eventually answered that question, right?
They did, at every level. In May of 2025, the Court of International Trade ruled that the IEEPA tariffs were unlawful. The Federal Circuit affirmed that ruling in August, sitting en banc, which means the full court, and then in November, the case went to the United States Supreme Court. What was remarkable at oral argument was how skeptical the justices were on both sides of the ideological spectrum. And on February 20th of this year, the Supreme Court decided 6-3, IEEPA does not authorize tariffs, period.
I remember hearing some of those arguments and thinking, wow, finally a bipartisan law, and everybody's looking at it going, wait a minute. And it was 6-3. So what happened after that ruling?
Within days, the Court of International Trade issued what is being called the Universal Refund Order. Judge Eaton directed U.S. Customs and Border Protection to refund IEEPA duties to importers of record. And Judge Eaton himself noted from the bench that interest is accruing at approximately $650 million per month on the outstanding balance. Customs and Border Protection, or CBP, then came back to the court and said, we have 53 million entries, $166 billion owed, and our systems cannot process this immediately. The judge gave CBP the time to build a new processing system called CAPE. But I want to be very clear, CAPE going live does not mean refund checks are going out. It means the application process is open. What happens after that is a different story.
And I want to hear that story. So $166 billion, Michael. For a business owner watching right now, how do they know if they would be part of this?
The key question is whether your company was the importer of record on entries where IEEPA tariffs were paid. That means your company's name is on the CBP customs entry as the entity that imported the goods and paid the duties directly to U.S. Customs and Border Protection. If that describes your business, you may have a right to recover those payments. In many instances, these tariffs may have been passed on to end consumers. But this is not a system to recover money paid by the end consumer. It is only for the importers of record that paid the tariffs directly to CBP. Stanley Law is reviewing cases where companies paid $50,000 or more in IEEPA-related tariffs. If that sounds like your company, I encourage you to call the number on your screen right now. Our team will evaluate your situation at no charge.
It's good to know that call is absolutely free and people can be evaluated. We will have more for you coming up after this.